Freedom of the Press by Amy Claire Whitehurst and Aaron Miller. The Bill of Rights are the first 10 amendments to the U.S. Constitution that were passed in 1791. They were the result of negotiations between Federalists who wanted the Constitution to be ratified and Anti-Federalists who were concerned that the Constitution gave power to the government but no rights to the people. The Bill of Rights gave the people specific rights that cannot be taken away. The First Amendment is probably the most important one because it gives Americans some of our most basic freedoms like freedom of speech, freedom of the press, freedom of religion, right to assemble, and right to petition the government. These are the rights that the Founding Fathers considered the most important, and that is why they are first on the list.
So what is freedom of the press? Who exactly is the press? And can the press publish anything they want? Freedom of the press is the right of the people to get information from many different sources such as television, newspapers, radio, magazines, and now the internet. It means that the government cannot control what is published. The Supreme Court has heard lots of cases and made many decisions involving freedom of the press, but to understand them, you need to know a little bit of history. What did the framers mean when they said freedom of the press? We don't know exactly because it isn't spelled out in the Bill of Rights, but we do know a little bit of history that helps us understand what they intended it to mean. The members of the First Continental Congress wrote a series of letters to the French people of Quebec in an attempt to get them to help the colonists in the Revolutionary War. The first letter was written in 1774 and was called The Appeal to the Inhabitants of Quebec. In it, the Congress explained some of the ideas that they thought were important, including freedom of the press. In addition to just gaining knowledge about truth, science, morality, and arts from the press, they wanted the press to have the power to shame or intimidate public officials into acting honorable. The Founding Fathers thought that freedom of the press was an important right because it was a way to keep the government in check, so to speak. They understood that if the government could block information from being published, the public would be less informed, and government officials could become too powerful, like those of the British monarchy. Thomas Jefferson even went so far to say that our liberty depends on freedom of the press.
The first freedom of the press case was heard in 1734 before America was even the United States, and involved a man named John Peter Zenger who published a newspaper called the New York Weekly Journal. In 1733, he published information that said the governor of New York, who had been appointed by the British, had accepted bribes. Zenger's statements were true statements, but the governor was mad because his good name had been damaged, and he had Zenger put in jail. Zenger was defended in court by Andrew Hamilton, Alex Hamilton's brother. The jury found that Zenger was not guilty and said that no one should be jailed for speaking the truth. The U.S. Supreme Court had interpreted freedom of the press in many cases since then, but there are two cases that have set the law of freedom of the press: Gitlow v. New York and New York Times v. Sullivan.
In 1915 to the 1920s, during the Red Scare, there was widespread fear of communism and anarchism in America. Worldwide events, such as the Russian Revolution and the threat of a worldwide communist revolution, caused many Americans to be paranoid. Congress passed the Espionage Act in 1917 and the Sedition Act in 1918 to try to eliminate some of these threats. There had been a strike in Boston and Seattle, and a bomb campaign directed at public officials by anarchist groups. Many Americans saw the activities of organized labor as a move towards communism. Benjamin Gitlow was a member of the left wing of the Socialist Party of America, who did not like the U.S. government or the way that it governed its people. He published and distributed the left-wing manifesto in the Revolutionary Age newspaper, asking for the people to establish socialism as the form of government in the U.S. The manifesto called for mass industrial revolts and political strikes for the purpose of conquering, destroying, and annihilating the U.S. government, and listed specific actions that would be taken to accomplish this. In 1920, Gitlow was charged with violating New York's Criminal Anarchy Act by promoting the overthrow of the government by force or violence. He was convicted in the lower court. He appealed the case to the Supreme Court, saying that the charges violated his First Amendment right to freedom of speech and freedom of the press, and his 14th Amendment right to due process. There There were two issues that the Supreme Court addressed. Number one, did the New York Anarchy Law prohibiting activities promoting the overthrow of the government deprive Gitlow of his right to freedom of speech and freedom of the press? And number two, are the individual states required to uphold civil liberties granted in the Bill of Rights, like freedom of speech and freedom of expression, or do the Bill of Rights only apply to the federal government? The Supreme Court upheld the lower court's conviction of Gitlow and said that freedom of expression does not give an absolute right to speak or publish without being held responsible for the results. More importantly, they held that state governments like New York are not allowed to deny their residents the civil and human rights found in the U.S. Constitution. The court said that the First Amendment rights of freedom of speech and of the press are fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment. This is important because prior to this case, the freedoms found in the Bill of Rights only applied to the federal government, not the states. This case said that under the 14th Amendment, these freedoms are required to be given by the states as well. Justice Holmes and Justice Brandeis did not agree with the rest of the court. They said that the manifesto didn't show an actual danger of an attempt to overthrow the government, and that only ideas had been written and published, so Gitlow's right to freedom of the press had been violated.
In the 1960s, the civil rights movement was rapidly expanding through the nation, but particularly in the South. Civil rights leaders used nonviolent protests and civil disobedience to bring about change, and leaders like Rosa Parks, Martin Luther King Jr., and Malcolm X become important in the movement. In the early 60s, the world watched the Green Bureau sit-ins, the Selma to Montgomery marches, the March on Washington, and King's I Have a Dream speech in 1963. Montgomery, Alabama was one of the most important cities in the civil rights movement. To help strengthen the movement and to raise money, some civil rights leaders took out a full-page ad in the New York Times called Heed Their Rising Voices. This ad said that black students in Montgomery were involved in peaceful demonstrations to protect their rights under the Constitution, but that they were being met with an unprecedented wave of terror. The ad listed several things that had happened to these students, including leaders being expelled from school, police armed with guns and tear gas surrounding the campus, and police padlocking their dining hall to starve them into submission. Some of these statements were exaggerations, and some were completely untrue. Sullivan was a city commissioner of Montgomery, and his job was to oversee the police department. He sued the New York Times for libel publishing this ad that contained untrue statements. The lower court and appeals court found in Sullivan's favor, and he was awarded $500,000 in damages. The New York Times appealed to the U.S. Supreme Court. The New York Times argued that they had no reason to believe that the ad contained incorrect information, so they did not check to see if it was accurate. They felt that if a newspaper had to check the accuracy of every criticism of a public official before publishing an ad, freedom of the press would be very limited. If this happened, the press would not be able to check public officials as the Founding Fathers had intended. The Supreme Court in the 1960s was led by Chief Justice Warren, and it is known to be a liberal court with lots of interest in the rights found in the First Amendment. The Supreme Court in the Sullivan case was unanimous in its decision, which is very rare. They found that the New York Times was protected under the Freedom of the Press Clause of the First Amendment and that Due Process Clause of the 14th Amendment, and said that reports about public officials, even false ones, must have been made with actual malice or knowledge that it was false and intend to harm in order to lose First Amendment protection. Justice Brennan wrote the majority opinion, and he wrote about the intent of the Founding Fathers, especially Thomas Jefferson and James Madison. Madison wrote that the right to freely examine public character and to freely communicate among the people is the only way to guard every other right. He said that if people were afraid to criticize publicly, the First Amendment won't survive. 2 judges concurred with the majority opinion. That means that they agreed with the decision, but not with the reason behind it. Justice Black wrote that freedom of the press absolutely protects criticism of public officials, even if there is actual malice. He was even more liberal about protecting freedom of the press than the rest of the court.
Since these 2 important cases that involved the freedom of the press, there have been a few changes in law. In part, this was due to more conservative courts after the Warren Court. They placed some limits on the freedom of the press. They later held that public figures that aren't public officials may sue a news organization if information was recklessly gathered. In 1974, the court said that actual malice is not necessary if a person is negligent.
There are many other issues that will likely come before the courts related to these cases and freedom of the press. Some of the questions asked include the following.
Does the press have a right to place cameras in a courtroom? Today, they are usually allowed, although the trial may possibly not be shown live, and in some cases, a judge can refuse to allow cameras.
Does the press have a right to place cameras in the execution chambers in a death penalty case? This has been discussed because several executions that have been messed up, and a lawsuit was filed last week that reporters should have the right to witness executions.
Do journalists have the right to refuse subpoenas if they are asked to give up sources? The Supreme Court has said that freedom of the press doesn't give journalists the right to refuse subpoenas, but some reporters refuse to give up their sources anyway. There is a case right now that the Supreme Court refused to hear, where a reporter has refused to give up his source for information. President Obama wants him to be forced to give up his source.
Can student newspapers print anything they want and call it freedom of the press, or are there limits? Can they print derogatory information about the school, administration, teachers, school lunches, or anything else? The Supreme Court has said that limits to freedom of the press can be set in school settings. Can the Justice Department listen to phone conversations or read emails of reporters and editors in order to find out who has been leaking classified information? This really happened with the Associated Press in 2013, and the court hasn't decided on the case yet.
What exactly is the press? It was originally called the press because newspapers and pamphlets were printed on the printing press, but the definition has changed today. We know the obvious media sources are the press, but what about bloggers, independent journalists, and social media? Are they the press? For right now, the courts have said that the press includes every sort of publication which affords a vehicle of information and opinion.
Since the writing of the First Amendment, the press has served as a watchdog of the government. Some call it a fourth branch of government because it keeps the public officials in check. Without freedom of the press, the people don't know what the public officials are doing. Today, it is even more important to balance because of the immediacy of media, internet, and news. News reaches millions in seconds now. As we have recently seen, with new technology comes new questions regarding the First Amendment and the rights to the people. Who knows what rights we will have as we get older.